May 17. I'd ask for a confirmation of quorum.
Commissioners Wilson,
Present.
Ackland absent, Burke,
Present.
Castleman,
Present.
Wilson, Wiggins,
Present.
Hubach,
Present.
Stidham,
Present.
Daring,
Present.
Moorhead.
Present. Please stand for the pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, moving on, I'll entertain a motion to dispose of our minutes, previous minutes. We have a motion to approve the February 21st minutes. Do I hear a second?
Second.
Motion second, any discussion? All in favor? Passes unanimously. Moving on to unfinished business, we are thankfully into Article 5 regarding the city manager, section 5.1. We are, I know there was some language request. Turn it over to staff for that.
It was my understanding, I think I may have stepped out of the room prior to this in order to go to the Planning and Zoning Commission, but there was a request for information regarding other charter cities and the removal provisions for the city manager. Am I incorrect on that assessment, or is there something different I was supposed to be looking at?
I tell you what, since Mr. Fearborn was the one that was to do that, I would really rather prefer that Mr. Fearborn then, because he wrote that down exactly what we wanted. So we'll move past the staff report on that. Do we have any other further discussion on section 5.1?
On which one, 5-1?
5.1.
We went ahead and we said we wanted a, what was it? That appointed by the mayor, the city manager appointed,
Oh,
Yeah.
and we changed that, didn't we?
well, that's the language that we're talking about, is the
Is
very
that the
first
advice on
sentence.
consent?
About adapting that it is not an appointment by the mayor, but it is basically, it is a recommendation of the mayor, but it is the council who actually votes with the execution of the agreement by the mayor.
I have information with regard to that I think I can provide additional input on. You're talking in particular the advice and consent provision that we've got there, is that correct?
Yes.
Okay. Now, Mr. Fearborn is walking in the room, so I do this with some degree of concern. Throttled, because I have the opportunity to go back and quote the framing and the founding fathers again, but I will refrain from doing so. I would tell you, I have had the opportunity to go in, and what I will tell you is advice and consent is generally identified as a term of art within the law. There are a number of articles that are available. I was not able to find a substantial number of case law from Missouri that identifies advice and consent. But if we're talking in terms of, law journals, I've got an Adam White from Harvard Law School back in 2004, where they've got an overview of the advice and consent language and the ongoing battles between the original framers, and I'm not going to go into detail on that one. But the one I do have is a 1973 case law regarding it, and it talks about how, for example, and this is out of Missouri, State versus Kaysen, 507 2nd 405, certain executive appointments are subject to advice and consent, identified as a term of art of the Senate. By this provision, the Senate is given the right to confirm or reject appointments within the executive department, and thereby to have a voice in what otherwise would be a matter confided solely to the executive department. What it boils down to is the language for advice and consent is utilized as a term of art, where it is identified for being generally including the right to vote on approval of an appointment, not necessarily to provide, here's who we propose to have as your candidates that the mayor would propose for us for a particular board, or mayor, this is who we would like for you to designate to serve as the city manager. You all still get the opportunity to vote. Advice and consent, thumbs up, thumbs down from a city council perspective as to whether or not that city manager is to be appointed. If you decline to vote for that city manager, it would be in the mayor's prerogative then to provide another name that would be provided or brought up before you go for consideration. Looking at it from a really historical standpoint, and I can go back, one of these specific comments was, and I will utilize this for the executive, it will be the office of the executive to nominate and with the advice and consent of the legislature to appoint. There will, of course, be no exertion of choice on the part of the legislature. They may defeat one choice of the executive and oblige him to make another, but they cannot themselves choose. They can only ratify or reject the choice he may have made. So a little bit of language there for you that I might be able to refer you back to on the advice and consent. If you all are interested in the Harvard Law Journals, I'm happy to provide those to you, or the Black's Law Dictionary definition. But what I would tell you is advice and consent truly is a term of art in the law that has meaning and significance.
Okay? Any questions of staff? Any comments or?
Well, it went so fast that I couldn't hardly keep up with him other than that. Except I did get some thumbs up and thumbs down part of it there.
Well,
But I'm serious about it. I wish you wouldn't talk quite so fast. It takes a little while with this hearing thing for it to get to my brain, and so if you just would talk a little bit slower, everybody, I could hear you much better. Because that's, as you know, on a cochlear implant, it bypasses your ears and goes straight to your brain, and so that takes me a while to get there. And so if you all will just bear with me, but I had some things that on here.
go ahead
I
if you
wanted
have
to-
something to.
on the city manager, one of them was about, he should be responsible to the mayor and the council. And I wanted to delete the word mayor because he's responsible to the council. The other one was,
Ms. Schubach, that's in a different section though.
isn't that on,
That's in
what?
5.2.
Is that 5.1?
It's
No, I'm on-
5.2.
I'm on 5.12, okay. I'm not just ahead of you, thank you.
Well, and we can definitely bring that up when we get to
Oh.
5.2.
I know that, what, the other one is, the acting city manager, that's in 5.1 appointment and terms,
Yes.
when they talk about it. Haven't we gone past the place where we have an acting city manager?
Well, Ms. Schubach, that's an interesting question. Administratively, the way that would work is if a city manager vacates their position, during the point of time that that position is vacated to the point to where the council, through using advise and consent, elects a new one and the contract is signed, there is a gap. And city affairs, we need an administrator to handle those city affairs. So normally it would, no different than like the president, it would follow the vice president. In this case, the city manager would fall to the assistant city manager. Any new structural change, in essence, the organizational tree would identify who a successor would be.
But you mentioned in there the acting and the assistant. An acting is not the same thing as the assistant. And that was what I'm getting at. If we have grown so much to where we have not only a city manager, but we have a full-time assistant city manager. So if we've got a full-time assistant city manager, why do we need then to also have an acting city manager? It seems to me like there's no need for an acting one if we've already got in place, we've got a regular one.
If I may,
Yes, Mr. Burke.
that's addressed in section 5.3, which.
Well, no, I'm still on
I
5.1.
I realize
It
that,
references
but
it again
there
later.
is a reference to
Yes.
that specifically
There's
in
a
5.3.
qualification there.
No, and it seems to me like you wanna wait till we get to that one then.
Well, I think it will work for you better there.
Okay,
maybe.
Because it
But
defines the
we'll-
role of the acting city
We'll
manager.
reference back to
So-
5.1 after we address 5.3 to make sure that they match. Does that
okay.
sound
Because
good?
to me, an acting is not the same thing as an assistant.
That is correct. I would agree with you on that. On section 5.1, we're still trying to make sure we properly read out with the first sentence. There was a desire, or at least consideration, to change the language there to make sure that it is the choice of the council to choose a city manager. based on what I'm hearing from the staff report, politely put, whether the mayor appoints expressly or implicitly, the act is still there that somebody has to be put up, and then the council still does, with advice and consent, ultimately control the approval or rejection of this individual. And so, does anybody believe that this sentence is not definitive of the council's authority? I'll take your, go ahead.
That
Mr.
particular
Burke.
sentence is addressed from a motion from last, I don't know that we voted on it, and on page 4.
Yes.
It's actually a withdrawal of your motion, Mr.
Oh.
Burke.
All right, thank you. All right, well then, thank you
For staff,
thank-
for staff research.
Thank you, thank
and
you.
the,
All right,
commissioner staff.
so we're right on track, okay.
Fair enough.
Thank you,
Okay.
sorry.
Not a problem.
Thank you for that clarification.
With that being said, I believe that the there's an implied admission by silence, so we will assume that 5.1, there's no other pending issues regarding old business. Moving on to new business, under Article 5, we're moving to 5.2, powers and duties. Ms. Hubach, you mentioned the second sentence, so if you would please, this is a perfect time for your point.
That the city manager shall be responsible to the mayor, is that the one that you're
That's,
talking about?
that's correct, so
Yes.
please.
He's not responsible to the mayor, he's responsible to the council for the administration of all city affairs, and then under the charter. And then, I've got some on A, B, C, G, and we'll just take care of that one beginning. City manager shall be responsible to the mayor and the council for the administration of city affairs.
I'm gonna break a little protocol here, since we do have Mr. Fearborn. Mr. Fearborn, can you offer up an example where you are responsible to the mayor?
I need to reference code, but there are certain sections of the code that, for instance, especially in the charges associated with meetings where I am conferring with the mayor, there is also a section, I wanna say in here, where the mayor and the council can comment to the administrative affairs of the city, but cannot interfere with those. But that wording includes the mayor along with the council, sir.
The best example is calling a meeting. The mayor can call a meeting. When he calls the meeting, he instructs you as the city manager to issue notices for said meeting.
That's one of those examples, yes.
Would there be another one upon signing of documents where there are signatures for the city manager and the mayor to signify that something is, or certify an ordinance, or is that?
That's actually an interesting component of this. You'll remember that the council directs the mayor to, to approve an ordinance. But within here, if you look at I, under 5.2, the execution of documents, with the exception of city-to-city intergovernmental agreements, the mayor actually authorizes the ordinance, but I am supposed to be authorizing the agreement. We've actually, we're working even as we speak on how that's gonna move forward, because we technically haven't been doing that, even though it's called for in here. So it's good that we're reviewing the chart. This is repeated in a section of code as well, that I authorize the documents based on instruction from the mayor, which is given by virtue of the council. So it's actually a 3-step process. Council authorizes the mayor to execute the ordinance, which is authorization for me to sign an agreement. So I
So technically.
am subject to the mayor's actions, because the mayor could technically
any other questions regarding the city manager in relation to the mayor? Ms. Shubak, do you have anything further on that point?
Well, I'm not sure, because I've got several other things on down here. It talks about the city manager, and I think it mentions the mayor
Okay,
there.
how about
like
we
on the
take them,
budget, and then other reports.
Ms. Shubak, how about we take them in small chunks? So let's start with item A.
Okay,
And this is open for anyone. It's regarding appointment and removal of employees. Does anyone have anything regarding item A?
I did, because where it says including the city clerk, I took exception to that for this reason. The city clerk not only works for the city manager, but she is our employee also, because she does our minutes, and we refer to her for different things. So it seems, didn't think that the city clerk should have to be responsible for her job, his or her job, to the city manager. That's one position that I thought belonged to the city council. We should decide whether we want the city clerk to be terminated or not. And that was my, unless there's another reason that you all can come up with, because we've had it in the past. I'm assuming, and everything's all right now, but I'm assuming that somewhere in the future it might not be, because in the past, we've had it where the city manager and the city clerk did not get along with each other. And sometimes the city council got caught in between.
Okay, Mr. Stidham?
What's the protocol as far as the city clerk? Does the city manager or the council do her evaluation, and who does she report to now?
Okay. Before I asked for a staff report, give them a moment to digest that, Mr. Wiggins.
5 months ago, we've already addressed the city clerk's relationship to the manager in section 3.9, where it specifically states the relationship of the city manager shall appoint the city clerk. I mean, that's the first sentence, the first half of the sentence, with the advice and consent of the majority of the council. So it's the city manager's job to appoint the clerk on the advice and consent, and then the city clerk shall perform such duties as may be required by law, by the charter, by ordinance, or by the city manager. At no point does it state anybody else that she is, in our case, she, the city clerk. The duties are by law, charter, ordinance, city manager, period, end of statement. It's already addressed.
Okay. Does staff have anything further to add on that?
I'm simply going to comment back to 3.9 as well.
Okay. Very good point on that.
It's,
Fair enough.
I think it's pretty well stated already, and so this doesn't supersede it or anything.
You know, for me, again, as naming him the chief administrative officer, we are, as a council, are a legislative body, which means we really, on very limited instances, should be involved in hiring and firing matters. While the city manager does, or city clerk does serve a lot of valuable duties and tasks for us, and we find her very valuable, I would also point out we have another staff member here that is also invaluable to each of us with the chief of police. But in the same instance, while she may serve a role to us and communicate a great deal with us, there still needs to maintain a degree of organizational structure, and that we have already under the charter allocated that to the city manager.
Well, one of the things that I was thinking in terms of that, in some of the other cities in the area and elsewhere in the United States, where they have the city clerk does the city clerk's duties, but when the city council meets, they have their own special clerk to take their minutes and do that. So I know of some cities that do that, and I'm figuring that, would that be considered the same here? Could we do it? Does this limit the city council from having its own clerk? It shouldn't, should it?
Well, without going back and re-arguing 3.9, I would ask the staff though, in regard to the city clerk and Mr. Fearborn's ability to administer his employees, I believe we have had instances where we had non-city clerks actually take the minutes. I'm specifically thinking of Ms. Johnson,
Once a year.
that there are instances where the city clerk does not actually take the minutes for the council. But still, because it is a staff member assigned, that staff member still is under the expectation of providing the exact same service to the council.
But suppose we wanted to have like a court reporter, we would take it down exactly as we speak. And something, would that eliminate us from being able to use a court reporter as our secretary, as our clerk, if we wanted one?
Mr. Fairborn, would you believe that to be a process, not necessarily an employment matter? Because
Absolutely.
the clerk can choose to, as she is currently doing, I know there are a lot of times she's feverishly typing, but we also are recording. Court reporting is merely a memorializing of an event, and it can be done by anybody. Technically, Ms. Warner could have a court reporter come in to assist her if it was needed, and that would be a staff decision, not so much related to the charter and not even really to the code, I believe.
Right.
Mr. Zerk.
I would argue there's nothing that would prohibit having a court reporter come in order to transcribe a particular meeting, but the city clerk's position is much more expansive than that. We're talking about maintaining the records of the city, documenting requests for information. We're not just talking about a transcription service that would be court reporting in relation.
But that, the court reporting would still be a function, not necessarily a branch of the department.
Yes.
It's a process that Ms. Warner can choose to utilize or not, and based on, and so it doesn't affect the structure of the administrative chart. So we still have the city clerk answering to the city manager.
Yes, good, but I remember an incident happened when when the city council didn't get their minutes, and the reason we didn't get our minutes was because she had been given extra duties by the city manager at that time, and she didn't have time, so she had to do the city manager's duties came before the city council's duties, and I take exception to that.
Well, and as a councilman, I would take exception as well, but the person I would take exception with would be the supervisor of the clerk who prevented them from doing the minutes, which would be the city manager, which would stay consistent with the city manager being the chief administrative officer. They're in charge of the staff. If their staff makes mistakes, as Truman once said, the buck stops here. And so, I don't think that I'm not, unless other members of this group feel that differently, I'm not sure that we need to necessarily carve the clerk out. And since we already talked about that under 3.9, I don't think that it requires a change at this point in
I think the
5.2A.
fewer people that answer to the council or that report to the council directly, the better. And I think we've gone, in most cities our size, council has one employee, and everybody else answers to that employee. And I don't see anything good happening out of that process, adding another employee to the
Well,
council.
and if you see how our council operates, typically, the mayor speaks to the council, but normally we speak to Mr. Fearborn, and then Mr. Fearborn may choose to delegate a staff member to speak on a particular issue. So even during the council meeting, there's a recognition that we are technically speaking to our one employee, and then by his generosity, he may bring in somebody who can offer a better explanation of something. And in that instance, now I've only served under 2 city managers. The previous city manager was not as willing to let staff step up and be the presenter of information. He was a little more controlling of that, and so, but that is a management style more than a charter or ordinance issue. Yes, Mr. Burke.
I also contend that some of these things have changed in the era of YouTube videos and documenting everything on video, that things that happened before the advent of video made it harder. It was more difficult in the past than it is to do now, to do minutes. Because if you make a mistake, I have gone back myself said, did I really say that? And I've looked at the minutes, I'm like, did I really say that? And it was in quotes, and I'm like, I really did say that. It's exactly what I said. I just don't recall saying that, but I was wrong, and the clerk was exactly right.
Yes, Mr. Castleman.
Am I wrong in thinking that the implication of the minutes is that we're anticipating what is said? Because we tend to follow Robert's Rules of Order, and Robert's Rule says the recording secretary records what is done, not what is said.
Yes, absolutely, absolutely.
That's right.
I think any meeting where there's an anticipation of a great detail of controversy, you might, as you say, order a specific transcription of this meeting, that meeting, in anticipation of something extremely involved. Other than that, it's what's done.
That is correct, and in fact, I've been the benefactor of that numerous times, making a number of verbal blunders up there. Thankfully, Ms. Warner sanitizes that a little bit as Mr. Moorhead agreed, or whatever, or disagreed, or, but yes, what is done, not as what is said.
I always like discussion.
Well, also,
Ms. Derrick,
Discussion ensued.
yes, discussion ensued. Yes, Ms.
and
Yvonne.
also under A, it says that he shall do he or she shall do certain things by the charter, except as otherwise provided by law. Is there any examples that you can give us what might be otherwise provided by law? Or is this one of those catch-all phrases that we put in things to cover?
Before I turn that over to staff, because that's actually a pretty deep question, my initial interpretation of this was exactly what you said. It's more of a catch-all. There could be a situation where it's incidental, but the council or something occurs where an ordinance gets passed that is technically in violation of like a state or federal law, where the city manager could act on that resolution, but yet it is in violation of the law, so therefore the law says he cannot. That's my interpretation, where that is in there to catch. So he can't just do things because we put it in the charter if it is except as otherwise provided by law. Now, Mr. Zer, you probably have a better explanation.
Yeah, I actually,
One of the most important things by law would be the administration of elections.
Okay.
It would be a couple of other simple elections. A couple of other simple examples would be compliance with liquor laws that are mandated by statute, as well as the requirements of business license that requirements are required by statutes.
And Ms. Warner has given that within the parameters of the city clerk, that this is actually for all employees. I can't, it said I can remove employees, well, I can't discriminate in the removal of an employee. I can't hire an employee by our charter law if I'm going outside the parameters of the budget and the budget book that's on. I can't just create a position without going to you all and saying, you know, this position is now in the salary chart. Those are the parameters of the law in a real nutshell.
Any other questions regarding subsection A? I think that seems to be pretty intact. B is, I believe, kind of an offshoot on that, but I'll stop for a moment and ask anybody have questions of B. How about section C?
Well, in section B, we've got one, and then that has to be the park department, because there is designation by law, it is supposed to be separate. And do other cities within the city itself have memorandums of understanding? I understand having that between, say, like Belton and Raymore, or Raymore and Peculiar, or Raymore and Kansas City, or something, you know, a memorandum of understanding. But do cities have memorandums of understanding within their own confines? You know, like would the police department, for instance, have a memorandum of understanding with planning and zoning? Or just use that as an example. Do they?
Mr. Fearborn?
Is it common, ordinary to do that?
The file is thick on this one, and I can go back and look at it. I know that when we originally drafted the memorandum of understanding, Mr. Willard was principally involved in that process, and I know that he had done research on other cities that had similar arrangements. I can provide additional detail if you're so inclined, but I know that there are other examples out there that he drew from in drafting that memorandum of understanding.
So within a city's administrative staff and everything, each, different ones of them have them.
And the basis for that is because the park board is established under separate statutory provisions. So there's an entire separate section of statute dedicated for what park boards are allowed to do and what they should be doing. So we have documented the arrangements of how that inner working is going to be. I know that the file on the matter is thick, though I can't give you the examples right now. I am happy to do so.
Can the same thing apply to the other departments like planning and zoning?
I don't know where we would have any conflict with those other departments though, or where there would be an issue as to the employment of the other departments, because the memorandum of understanding focuses on the employee relationships between the park individuals within the Parks Department and the city manager. You have a city manager who is in charge of all employees, and then a Parks Department where there is some reporting to the park board and the Parks Director. The memorandum of understanding is set up in order to be able to address that potential conflict between the two of them. It helps to alleviate any potential
Respectfully, I'm gonna
concerns.
go ahead and stop this line because actually we're covering the city manager and his relation with the departments. The question is straying into matters that affect the boards and commissions, and that's a separate section that we'll get to. So with all due
Well-
respect, I think we've strayed a little too far out of the realm of this.
What I wanted to know was, is it possible then for a city manager to have a memorandum of understanding with other departments in the city?
Well, right now, this section states that the city manager shall direct or supervise the administration of all departments. I guess theoretically, instead of a memo, we could do a memo of understanding. That's kind of a polite way if you're gonna do it. But he doesn't need to do an MOU because he's their boss. So I mean, I think that's pretty conclusive. I would like to bring up item C. There is an issue on item C. Actually, Mr. Fearborn has been too professional and polite not to exercise this, but one issue I did have, take great notice on this is, and shall have the right to take part in discussion but may not vote. Normally, our city manager does take part in the discussion of every issue. It is normally because the mayor asks for a staff report. Now, periodically, sometimes the council will get a little astray, and the staff has kind of asked to participate to help clarify something, but actually, based on the general language here, it does not state a limitation. Therefore, the right to take part in discussion is very broad in general. Mr. Fearborn could really become pretty active in each of the discussions if he wanted to.
Meaning he could provide opinion on,
There's no,
before the
this does
vote.
not limit him from that. He does have the ability to do so. Does anybody, I mean, I don't see it as a concern. I am just merely commenting on this. I would trust this city manager because based on his track record. But theoretically, he could have a fun night one night and jump in and be the extra mayor or an extra person on the dais.
Staff would tell you, sir, once the question period of an agenda item is over and it's council discussion and the mayor calls for discussion, staff is out of it. Unless we are asked questions, that is a sacred time for the council.
I would just only extend that is only by his professionalism, that's great.
Well, in some cities, they only allow the city manager to give the reports, and then if there's something special, he can call upon one of his others. But I like the way in which ours does it, because he calls upon them, they make the report from the department, but he doesn't have to do that. He can give all the reports if he wants to.
Well, and he can do more than just give reports. He can give conclusions and opinions. we're blessed with someone who doesn't abuse that process. But just since we are talking about this, some of these sections seem very simple, and we should be cruising through a lot of these subsections. This is not a controversial article. I just wanted to throw that out there just as and can't let him get by with no criticism. Okay, if no other issue under Article C, Article D. Any issues with D? E? F? G? Ms. Hubach? What letters do you have?
I know she referenced G.
I thought she did too. Under other reports, ma'am.
Other authorities, council may consider. I'm trying to think, and based on the past and based on the future of what we're going to, because we're really looking ahead for 10 years. And I'm just trying to think if there was anything that would come up in that. Right now, I can't think of anything. But on other reports, maybe the rest of the,
That's a pretty
members
broad
here.
statement there, gives the council a lot of flexibility over the next 10 years to make those whatever they want. It's a very broad statement, as it is, so I think it gives the flexibility over the next 10 years, because make such other reports doesn't specify what they are, so
No.
it can be any of them, really, so I think it's pretty broad.
Maybe a catch-all.
Yeah.
Well, and I will say from practice, this is pretty broadly used today. The city manager frequently is asked some pretty left field questions by council members and requested to put together chart summaries, historical information that no sane individual would ever preemptively address. And so, we've always had staff provide, if we ask, they provide. So I think that's, I see that as widely used and never poorly used. But, any other issues on G?
I'm down to J.
Okay, then I tell you what, quickly, anything on H or I? Okay, and then so J, other duties, Ms. Hubach.
Yes, I just noticed it in there that it says city manager shall perform such other duties as specified by the charter or required by the council. And I just made a note here that no mention was made of the mayor, so is there ever a time when we want him to give us any kind of, have a duty regard to the mayor?
Ms. Hubach, and I mean this with all due respect with our mayor here, the jokes are flooding into my head too fast for me to say them, because I would love to be able to say we should go back to Article 4 and throw a lot of other duties in there and just say we get to make the mayor do whatever we want, whenever we want, and he has no call. But we do have very limited, the mayor has very expressed limited duties. And I think one of the things you've expressed within the past is that you want the council to be a stronger body.
Yes, I do.
By nature, we've already done so by offering some limitations on the mayor. I think we would almost violate our general principle if we create too many loopholes or open doors to say, we can just ask the mayor to do whatever we want. And so I don't think that's, I understand that that's a very good question to pose, but I just think that we're not gonna necessarily like the answer.
Well, that's
Unless you
okay.
believe otherwise.
I just want us to think about it because this is our charter, and sometimes the simplest words can have some severe consequences.
No, no.
And I just want to make sure that we're aware of that.
Well, and I definitely respect the point to discuss, but I think in the long run, I think we've all agreed that we've already scrutinized the mayor a great deal, and I think we've covered that.
Okay.
Moving on to items 5.3, acting city manager. Ms. Hubach, now let's raise that issue you talked about.
This one here, we're on section,
5.3.
are we ready for section 5C?
5.3, yes
5C
ma'am.
then? Okay. by letter filed with the city clerk, the city manager shall designate a qualified person to perform the duties of city manager during the temporary absence. And then it goes on to say that the mayor has the right to revoke his choice. So there,
Only with the consent of
during
council.
such absence or disability, the mayor, with the consent of the council, can revoke such designation at any time and appoint another qualified person to serve. I had some problems.
Please.
My problem was having giving the mayor the authority to choose somebody else. Why not, maybe the council or something else? I'm not sure that I understand why we would need an acting one when we've got, already on the rolls, we've got, assistants.
Okay.
What's the difference between an acting, an assistant, a deputy?
Well, Ms. Schubach, I think the best way that I can analogize it to you is, we have Mayor Turnbow, but I am the Mayor Pro Tem. Now, I have expressed authority. When the mayor is gone, I become a partial acting mayor. I have certain duties that I then step into his shoes and I'm required to perform, no different than if he was here. Now, the code has some, or the charter has a couple of limitations, I don't get to veto and things like that, but in that position, if he is temporarily absent, all the chief affairs of the city can still operate. And the purpose there is, if the city manager steps away, while we do have an assistant city manager, that assistant city manager may not have the authority or the knowledge to be able to handle certain affairs of the city, depending on the role that has been assigned to them. But we do have to have a chief administrative officer, so at some point, we have to have somebody designated, no different than the pro tem. And so, I mean, obviously, Mr. Fearborn has a kind of plan in effect if he ever is absent, who would then step into his place, and that is the letter filed with the city clerk.
You see, they've got an assistant and versus an acting, and to me, they're conflicting.
Well, I think they're two different things. That's the key, Mr. Burke.
I think an example that we have had recently, there's been at least one, maybe a couple times where Chief Zimmerman has been the acting city manager when there were absences of both the assistant and the city manager at the same time. I feel like there may have been another person as acting city manager at another time that I can recall recently, but it escapes me.
Mr. Fearborn, do you have any history on that?
There, in fact, there has been an occasion when both Ms. Houck and I have been gone, that the chief was designated as the acting city manager. I would also point out, council member, if we are looking 10 years down the road, or if we are looking at 1 week from now, there will not be an assistant city manager, there will be 2 assistant to the city managers. And so I will need to designate at any given time, one or the other of them, if I am gone, as acting. As we grow, 8 years from now, there may be 2 assistant city managers. We may be big enough that we fall into that category. Again, I would have to designate one or the other of them at any given time. There may be a time when both myself and the chief are gone, so I will be designating Mr. Cataret as the acting city manager. There may be circumstances where even he would be unavailable to do that, or not comfortable with that, in which case I may have to dip down and find somebody else in that particular instance. So I think it's important that we keep the flexibility of who gets named for this, still with the ability for the council to go, hey, wait a minute, he designated that person, but because he was gonna be out in the hospital for a week, but now it's looking like about 3 weeks, and we got this thing coming up, no offense, but we're gonna override his decision as the council, and we're gonna name this person as the acting city manager. So I think this covers everything, any contingency that might come up now or in the future for that.
Do you feel comfortable with that, Ms. Hubach?
Not really, because having come from a government employee, I feel that there's all these things having to do with whether you're a deputy, whether you are an assistant, whether you're an associate, you know, the terms mean, titles mean a lot. And it doesn't make any difference to me what it's called, but I think we should trust the judgment of the city manager to have his replacement rather than the council or the mayor doing it. Am I wrong?
Well, I guess, as a for instance, Jim leaves, okay? Who is going to be the city manager? And it's not gonna be somebody here that you're appointing as in an acting role. You're probably gonna go out, do a search, and find another city manager. You're gonna need somebody, though, in the interim to be the acting city manager. And I think that that's this application here, rather than in a temporary instance where he has the authority to appoint who is the acting. I think that's his job, and you're right about that. But I think it's your job as a council person to appoint an acting person if he leaves, if he's gone, or whoever is in that position is vacated. The same thing that you did with me when I left, you appointed Roger Mayberry as the acting chief until you found Chief Zimmerman, who then became the police chief. But you had to have somebody in that acting leadership role. And I think it's as simple as that, really.
Ms. Hubach, I'd also add, because I think your concern is really the second sentence, not so much the first sentence. Because the second sentence is the role of the mayor and the council stepping in. If Mr. Fearborn is gone in the first sentence, it stresses temporary absence or disability, where the mayor and the council may step in and try to revoke a designation would most likely occur if that disability or absence grew longer and the person that was assigned, either by choice or by poor conduct, could not achieve what the council and the mayor wished to do. And so in those particular instances, remember, we hired the city manager. We don't have the authority to hire his successor. And that first letter is more of a line of succession letter. But if we get somebody that Mr. Fearborn has faith in, but the council and mayor does not, we still have the expressed ability to step back in and retake control over who would be the acting city manager.
Well, if the rest, go ahead.
Mr. Stidham.
I don't disagree with any process that we've been talking about. My concern is the wording where it starts with the mayor, because it says the mayor, with consent of the council, may revoke such designation at any time and appoint another qualified person to serve. We're contradicting ourselves. If the council is going to direct the appointment, the emphasis, as I read this right here, is on the mayor.
Yes, yes. We're kind of back to where we were before, where it is an active step by the mayor to initiate the selection of the individual. And then, and Mr. Zer, would you not agree, maybe a substantive change would be with the advice and consent to stay consistent with the code of art?
So you use
That- Yeah, just the wording.
If we were to
because
mirror,
5 years from now, somebody could jump in here and argue till tomorrow.
Yes.
if we were to mirror the first sentence in 5.1, I think that's what would address
Yes.
what you're saying. Since we addressed it there, it would be the same in
The mayor
this
with the advice and consent.
of 6 of 8. I mean, we could put the whole sentence in there if we needed, or we could refer back to that.
Mr.
in
Wilson's
5.1.
also brought to my attention, if you go back to 5.1, we also have a similar qualifier, because we say the city manager and the acting city manager, comma, should the position of the city manager become vacant.
Oh, right.
So we have in more than one place in this article identified a condition where someone would move into the acting city manager role.
It could even be somebody outside of the employees in this area then, couldn't it?
It could, but then we have the second sentence, which allows the mayor and the council to stop that.
So it could, it's already inherently in there.
And this is maybe not the best example, but I was fighting to try to think of an example. You recall, I think Kansas City, Missouri had a city manager who actually moved his office to his home and appointed his wife, who was not a city employee, as an advisor, and actually tried to assign, authoritative roles. And the city council had to step back in and put a stop to it.
That was Funkhauser.
Well, that was Funkhauser. I didn't want to say names, but yes, that was Mark Funkhauser. So, with that being said, Ms. Hubach, do you feel that this has been better explained?
Yes, I think I understand what you're coming from now.
Okay. Section 5.4, dealing with the performance review. This is an issue that we're going through right now. I guess for the record, I'll go ahead and point out, it is confidential. So it is something that is strictly an evaluation from the mayor and city council. We do it and we start the process in February and it runs through March, and we always feel like we don't have enough time. Because one, it's given a lot of consideration, time and respect, and a lot of discussion.
I noticed once on the internet, I went on, and some of the cities actually publish what the evaluation is of their city manager. Is there any value in anything like that?
See it. I mean, we,
Put that on Facebook.
as citizens, as put on Facebook, yeah, don't do that. As citizens, we are putting our trust in the council. We are electing our elected officials, and we are thereby giving them, granting them power to appropriately handle the performance evaluation. So, I think that we don't necessarily need to know because we're already entrusting the council to do so.
Well, I wasn't saying that we didn't trust them, I was just saying it was whether you make them public or not.
Right, but
Well, I guess if they
I
were
don't
looking
think so.
for a position
And you're gonna get,
later.
I couldn't see any value to it, but I'm just,
yeah, I mean, my performance evaluations that I've always had with various companies have been pretty much between me and my manager. Yes, they're on file in HR, but it's not, obviously, this is different because it is a public employee, but I don't see any reason to make a performance evaluation public.
Merely for perverse curiosity, that would be
Yeah.
about it.
And you'll get 13 people out of 23,000 that'll bitch about it, and it won't be an issue. They'll make it an issue that's a non-issue.
Thread that we run with
Yes,
that?
I am referencing
wow.
Facebook.
I do
Just
not
keep
see
on
the
moving.
I do not see the value
No.
in publishing the King of Ramor's
Doesn't-
evaluation.
yeah.
The king of Ray Ward.
Hang in there, comrade.
Is there a clause that we can have a whipping boy for the city manager,
All right.
to have an official whipping boy?
We can get through these sections. We can do it.
I'm sorry, I'm sorry, I shouldn't have said that.
I'm the one that cracked the joke and I allowed the room to get astray, I apologize. Okay, moving on to new business for Article 6. I will say, I guess, one last thing, Mr. City Manager, you got out of that pretty unscathed.
Thanks, sir.
Moving on to Article 6, Personnel System. We have Section 6.1. Do we have any issues of concern? Or two, or B, 6.1, A or B? Anyone?
what is the role of the council in reorganization of the city staff? I'm not talking about individuals, I'm just talking about, I've lived here all of my life and I've seen a lot of changes and a lot of things happen. But one thing that didn't seem to ever happen in all these years is we still had exactly the same kind of organization for our employees that we did when it was 1890. And we made a lot of changes and things, but we didn't seem to make much change in the way in which we did the business. And so I was interested in that. How do we determine what departments that are needed? Is it up to the city manager? Is it up to the council? Is it up to the mayor? Is it up to all of us? How do we decide how the city of Raymore should be organized?
My initial reading of 6.1, both A and B, is that this is, while it is in its own article, it is technically is slightly affected by the penumbra of Article 5, which is, there's a little bit of a shadowing overlap because the chief administrative officer has the right to create departments, committees, boards, and commissions. These are not like the art commission or the park board. These are within the city administration. There's purposely no mention of the council in this because we have already allocated to him the authority over this, so it just kind of is what it is. Does anybody interpret that differently, Mr. Fearborn?
Mr. Zur is calling it an enacting clause, but we see this a lot in the code where these were actually in there so that when the charter went into effect, everything rolled over seamlessly. And they stay in there because there's wording in them going forward. I don't know if that's technically an enacting clause. Sir, you probably know better than I do as far as the term of law that's associated with that. But basically, everything that was in place stays in place as the charter is passed, so that people don't think this is some sort of subversive attempt to, and then they just stay in there.
So the enacting clause is defined as declaring the source from which the law claims to derive its authority. So we would say in this particular case it is based upon the prior or the existing boards, commissions, and offices that were in place before.
And respectfully, Ms. Hubach, a lot of roles that cities and counties play are defined by state statute. And so unless the state legislature abolishes or changes things, repeals them, some rules we're just required to have. And in fact, there's a movement right now to consider abolishing counties in the state of Missouri. Because, for example, Worth County up in the northwest corner has 2,000 people in it. But yet they have to have a sheriff, a recorder of deeds, and a county clerk, and all these different things, and it costs a lot of money when they could go to the neighboring county, merge with them, save half the expense, and they only have to drive 3 more miles to get to the courthouse and the government buildings. When the counties were formed, it was based upon when somebody could get on a horse and ride during the period of daylight to be able to get there, transpire business, and get home. And yeah, back in the 1800s. Well, now we can span 3 counties in approximately 20 minutes. So life has changed, and I agree. There seems to be some antiquated departments or concepts, but it doesn't hurt that they sit there if they're not actively doing anything to hurt. So even if they're a little irrelevant, we still honor them just in case. Yes, ma'am.
Well, I'm thinking, it used to be you did everything with a pen and a pencil, and it took you all day long and everything. Now with computers and all these other kind of things that they talk about, you can do half the work, all of the work in half the time. So does that mean by then that you need half the employees? I don't know, or is it that the world has gotten so complicated that we need more people? And how do we determine as a council, how do we determine how efficiently our county, our city is operated? I'm not picking in any disparaging remarks trying to, city manager. I'm just wondering how we determine, because as I said, I've sat in a lot of council meetings, and as a citizen, I sat and I listened to a lot of them. And some of them were very efficient and some of them weren't, and I always wondered how you decided what it was that a city needed a way to operate and what it didn't. And so when I came to this, that was where I had it in mind. If we decided, if for some reason, it seems to me like we were very well organized, but if some reason we decided we wanted a department or to eliminate one, do we have that authority?
Well, funny you bring that up, and I'm glad you transitioned into that, because that's actually partially addressed under section 6.2, which is our last section to talk about tonight. And that is the personnel system. From an administration standpoint, the city manager, the council actually, this is where the council is involved. We adopt by ordinance a personnel code. And in that personnel code, we have the ability to make certain changes. For example, I believe within the last 12 months, we made a change regarding the way we rank employees by department. I think it was, Mr. Fairborn, it was a salary scale really, by department and by position.
I was gonna say the exact same thing you did, sir. This is the even though the city manager has the authority, but the council's input into my authority on that comes with you all's review and ultimate approval by ordinance of the personnel code, the administrative policy manual. So there is input and give and take with that. And as far as the departments and the structure of the departments is concerned, with due respect, I would say that the end of A, back in 6.1, says, until thereafter changed pursuant to this charter or by ordinance. You also have the ability, if you wanted to create a department, then that line is in there to allow for that.
So, but 6.2 does create a comprehensive personnel system for city officers and employees. And that deals with appointments and promotions based on merit and fitness, et cetera. And the code authorizes the city manager to promulgate regulations dealing with these. Mr. Burke?
I believe I have heard Mr. Fairborn within the last week or two say that is something that they are actively working on right now. The personnel code, or, isn't that
Very active.
correct? All right, that's what I thought. So
What is
that
the
will be
department
coming
the same
before
thing
us
as the people that
as a
work in it?
council very soon.
Yes.
Not
Right.
really.
And within that, it will have charts that show the hierarchy of staff.
Well, actually, I bring that to you every year
Oh, that's correct.
departmentally with the budget.
Oh,
When
yes.
the council approves the budget, and as a matter of fact, on either this Monday night or the following Monday night, we'll be bringing the budget amendment, which is the new organizational chart to you.
That's right. All right, thank you.
The term fitness means mentally and physically. So mental fitness.
Yes, yes. Just for clarification, if that wasn't said loud enough, fitness is also just physical as well as mental fitness.
The ability to do your job.
Correct. Correct. Does anyone have any questions regarding 6.2? This is fairly broad. We do not have a copy of the personnel code itself. But again, that is something the council goes through. We are merely limiting our discussion to the fact that the council is the one that oversees and creates that to pass to the city manager to administrate. Okay, any other issues regarding Article 6? We are at 7:05. We're at a unique situation because, man, we've got some movement going here. Yes, sir?
We still technically have new business, so we haven't completed.
Well, that's what I was about to
Okay.
address. And that is, under new business, Article C, or item C, it's Article 7 of our municipal court. Our city attorney has stepped out of the room here, so it will be difficult for Mr. Fearborn and really me and everybody else, although I took it upon myself a little over a week ago to think I could offer a deep explanation of part of the process. But Article 7 deals with our municipal court. Many of you might be aware of, there have been, over the last 2 years, 2 Senate bills, Senate Bill 5 and Senate Bill 572, that has completely changed our municipal code. And as a result, we have to make substantial changes here to both our charter and our code, or our ordinances. Article 7 is going to be substantially changed, and respectfully, Mr. Zur gave a very thrilling 1.5 to 2 hour breakdown of just, 22 pages worth of single columned or single lined information. The wholesale change of this section has, what I'm catching from other municipalities, it is overwhelming them. Now, I think Mr. Fearborn will humbly not want to brag about this, but our council has approved substantive changes that we believe has actually fully complied with and maybe be the model application of compliance regarding these 2 convoluted Senate bills. For the sake of this evening and just our sanity, I don't wish to open us up to discussing this, because I believe Mr. Zur needs to give us a brief presentation of this. He's gonna need to. But he's gonna really have to kind of tell us, because remember our whole thing of state preemption. If the state says we have to do it, it doesn't matter what we put in our charter in this particular instance. So I would like to table this issue until Mr. Zur can give us a good, strong example of language that will basically replace this. We're wholesale replacing this.
Are you making that motion?
And so I'm making the motion to table this. So we have a motion, a second, now we have discussion, Mr. Castleman.
No, I was gonna second that, go ahead.
Okay, Mr. Burke.
I could reference for anyone that wants to, that missed out on that, was it a work session, maybe
I think
was
so.
a work
2
session.
weeks
It was
ago,
not
yesterday?
filmed.
Yeah,
It
I
was
think
not-
I
yeah,
believe it would,
It wasn't filmed?
No, it was
it
previous.
would've
I'm
been-
pretty sure it was-
filmed?
used
Okay.
that.
But it was, we,
I might have-
it's on, it should be on YouTube if someone, if
It was
you,
either the last work session of January or the first work
right.
session.
So it is available for people that want the full length
That's right.
information, they could watch that if they did not attend. And then that would be helpful for people that missed that.
But if you read
Wouldn't
Facebook, they
this
tell you
be
where the
something
midpoints
that
are.
would be better just done by reference to state laws and not try to figure out word by word? Because every time we do, it would have to be changed. So can't we just say that whatever it is, judges pursuant to whatever it is, the state codes, and then not try to figure out how we're gonna do a judge or how we're gonna do that? If that comes up, well, we'll do it by an ordinance. But in the charter, just refer to judges by state law.
And Ms. Hubach, I agree with you, but my problem is even though this is not a large section, there are so many references here that I would ask that Mr. Zur give us guidance, so he can get us right to that, we just follow state law language, know where to put it, because under qualifications of the judge, there will be under, for example, appointment, and there are a few of these that we still maintain authority over. So I would not want us to disregard things that we still possess authority over, but the rest of it, we have to make sure syncs up with state law. So instead of us spending an hour chewing on something, finding out that Mr. Zur could have just come in 1 sentence, took care of it.
Are we sure he's not coming back?
I was kind of hoping and looking for him, but until then, I would just rather at this point table this issue, and then that way staff is instructed in the next meeting to come in with recommendations.
And those recommendations may involve doing exactly what Councilmember Hubach said, but it's still a wholesale change to the section. And I think Mr. Zur would like to, at least in a brief form, educate the council, or the commission to exactly
Yes.
what he educated the council on, so you all have a background on why you're making the change you're making to this. So even after all of that, and with Chief Zimmerman's background background knowledge on this, and with Mr. Zur in the room, as you know, and I've said it many times, we are going through code in tandem with this. It took 3 1.5-hour meetings to get through the code section of this. And a lot of that ended up being, okay, let's just end up referencing that we had to get our brains wrapped around it. It's a complex matter at this point in time in history.
It's changed everything so much.
Ferguson,
Senate Bill 5 and 572.
Yeah.
and the state legislature
The
in
racial
two
stuff?
different sections. Well, it wasn't entirely racial. They were looking at the administration of the courts, realizing that in certain instances, there was no delineation between the non-law enforcement and the non-judicial side, to where, politely put, and I represented a city, I won't say their name, but the city council meets in a trailer, and the police, there are less than 50 people in this town, yet they write more tickets in that town than the city of Raymore. And officers at a time were literally saying that there was a running wager each month where who could write the most tickets to an individual. And when they're going, I wrote a guy 13 tickets on one traffic stop, it became ridiculous. And at one point, the same officer was delivering an inmate to New Century down south of Olathe to their justice center, or the detention center. And on the way back up, coming up I-35, he was right about Miriam and saw a gentleman blow by him speeding. So in his Missouri police car, he turned on the lights and pulled the guy over and wrote him a ticket. So there are some examples there that are not racial based. It's that there are cities that unfortunately have used these as, and I don't want to say that you could ever have a community around a lake that could build a nice pretty community center when there are only like 300 people living in this housing addition off the state highway, that they actually annexed only the highway, but places have done that. And so it wasn't just race, but race. Ferguson, when they looked at that police department, they were noticing some inconsistencies, and they were looking at other surrounding ones in the rural communities and seeing some commonalities there. So when I read the changes, I was very surprised, because I, of course, as a defense attorney, expected to be very defensive about it, because it's changing the way I do things. Until I really started looking at it, realizing really how much better it will make our court system, how it will benefit the defendant more, because it's more structured, there's more information, they're more knowledgeable, a defendant is, to know where the courthouse is. But when you're walking into a room and it says mayor up on the dais, and then the judge walks out of a closet and stands up there, and when you've got 4 police officers standing behind them, the same officer that pulled you over is protecting the judge, it really gave defendants a really kind of, the system's out to get me kind of feel. There was poor disclosure about what their rights were. So now, like, we have to produce and post informative things just to let people know what their rights are. And things that really, most of the time, you would even think for us who are, I guess, theoretically not always law-abiding, but it's just really surprising how many people, even when they were like that, would go in and feel, this is a system working against me. And most jurisdictions were not a problem. Our Raymore courts were not a problem. We barely make any money off of it. But nonetheless, it was just, it's best practice, do you strive for the B or do you strive for the A? And there are a lot of courts that were hovering at that D- level. And so it just kind of picked things up. And in practice, I actually find my job easier and better to serve my criminal defendants. So actually, I'm embracing it more and more. Fines have been lowered. You think of tow truck companies wreck running. When you go into some of these courts, our court would typically charge $250 to amend a speeding ticket. I was going into some of these courts that were saying over $1,000 to amend, and you had to take their police department's community service program, and you had to pay fees for that, and they just would stack and stack and stack. Again, most wouldn't, but there are some that were, but, so it's really kind of snagging the cabooses and scooting them up toward the engine a little closer, I think. That would be at least my personal bias. And we still don't have Mr. Zard. Yes, Mr. Wiggins.
Was your, the town in your story, does it have a close proximity to a casino? Or is that a different small Missouri town that's known for their speeding tickets?
I think my story stands by itself, so, but there are a lot of small towns like that, so you don't know which one it is, but, nonetheless, like I said, if you saw the requirements, even just the bill itself, when those got passed, it just was really extensive. I mean, you're looking at things where it would have 14 subparts. I mean, it just huge breakdown of information and rules. And the city of Raymore has been able to satisfactorily do it. Other municipalities have satisfactorily obliged and adjusted themselves. Some probably haven't. I haven't run across any yet, but I bet they're out there, and they'll get into a lot of trouble. So.
What I liked about it was the fact that they make sure that the judicial system was not a part of the legislative or the administrative, that it had to be kept separate. And that made me feel that if I ever got into court, I'd have better chance, because it would be judges and it wouldn't be the political activities. I'm in favor of it. In fact, I think I was the one that brought it up for us to have a meeting on. But what I like about it is it's gonna make changes all the way through, so why not refer to it as by whatever it is the state law is, so that we're always current, because I know that our staff likes to be current, they like to be. And we did that when we had people running for office, and they had to pay the taxes, and we had something, and then the state changed it, and we had to change it again and everything. And if we could just refer to them by some of those things, we know that we can't change, and that the law is gonna be, the legislature's constantly gonna be changing things. Let's just refer to them and make our charter smaller and number of pages, but not have to spell out ever T and D and everything like that in it.
Right on. We do have a motion and a second on the table. Any more discussion?
I move the question.
Okay, the question has been called. All in favor of tabling this issue till the next meeting? Passes unanimously. Okay, we have no new business. Moving on to other. Does anybody have any other issues? Public comments, we do have a member of the public here, even though it's technically staff, but,
I've just let it wash over me. I'm sure I'll think of things later.
I feared you would have a Pavlovian response to the whole Senate Bill 5 and 572, but.
I blacked out for just a couple minutes.
Fair enough.
Talked about it way more than I ever wanted to.
But out of fairness though, if you would actually, I guess I've never actually officially asked you this question. Have you and your department had any major problems with implementing those changes?
No, and as a matter of fact, sort of to your point that we were never, and much of those two bills, those two Senate bills, dealt with exactly what you said, Councilman Moorhead, and that is those jurisdictions that were making a significant portion of their general revenue on the traffic tickets. That has never been the case in Raymore. You know, we are writing those egregious violations, obviously, that we come across, and those individuals involved in accidents and things like that, but keeping below the percentage that was actually dictated in those Senate bills was not an issue for us at all.
I would like to make a comment before we adjourn, to just merely say that staff has started putting the countdown sundial in here. If you look on 6B, technically we now have 7 regularly scheduled meeting dates if we stay on our schedule. And Ms. Daring, I believe the last time that they started having to accelerate meetings at the end to try to get this all done, I think we're actually, as long as we don't dawdle, I think we can stay fairly on point. I mean, item 7 is two pages. We will be talking a little about the judge, independent of what I mentioned about the two bills. But at the same time, I think we can start, most of these will start accelerating. So I'm gonna say, as long as everybody commits to kind of keeping the conversation quickly moving, please bring up any topic you feel is important. But if we don't rehash too much, I don't think we need to accelerate our meetings. Now, if we get to toward the end of April and we start getting a little panicky, then we may have to add a meeting or two. I would like to, I think we're efficient enough, we don't have to do that. But just since the staff has been offering these reminders, I just wanted to give a voice of support to believe we can do it. Any other issues before we leave? So we're technically done a tad early. With that, I'll entertain a motion to adjourn.
So moved.
We have moved and seconded. Any discussion? All in favor? Passed unanimously. Thank you. We are adjourned.